Welcome to the Deep Dive, the place where we take stacks of complicated policy documents and legal battles and really extract the high stakes human story hidden inside.
And our mission today is a truly critical deep dive. We're jumping into a moment of, well, fragile hope. This is right after the Comprehensive Peace Agreement, the CPA, so around 2009.
Okay.
And we're looking at these documents that detail this intense struggle to establish media freedom in Southern Sudan, which, was laying the groundwork for its own independence.
And from what we've seen in the sources, the freedom of the press and what would become South Sudan it was hanging by a thread.
It really was.
This isn't just a review of some proposed laws. It's the detailed, kind of blow-by-blow account of a massive policy struggle led by local civil society.
Yes, specifically the Association for Media Development in South Sudan, or AMDISS.
And they were fighting what they saw as this executive overreach, an attempt to stifle independence before it was even, properly born.
That is the core tension we are unpacking. I mean, AMDISS drafted 3 remarkably liberal, really modern pieces of legislation.
Based on international standards.
Absolutely. Best practices from around the world, core human rights covenants. They were aiming for a media structure that would guarantee transparency and accountability.
But there's always a but.
There's always a but. The minute those drafts went to the executive branch, the government of Southern Sudan, or GOSCUDIS, a series of very surgical late-stage amendments were introduced.
And these amendments just completely undermine the core principles.
Dramatically. Every single key principle of media independence they were built on was targeted.
It sounds like a perfect storm, the ideal democratic vision colliding right into the reality of power consolidating after a conflict.
Exactly.
So what we're going to do for you today is track that battle across 3 really critical pieces of legislation: the Right to Information Bill, the Southern Sudan Broadcasting Corporation Bill, and the Independent Media Authority Bill.
And to really get the intensity here, you have to appreciate the context. After the CPA, these legal reforms, they were seen as the essential benchmarks of democratic transformation.
Right.
If the public couldn't be informed, if the media couldn't independently investigate governance, then the entire project of open, accountable government was basically dead on arrival.
And that kind of transformation was desperately needed because the media in Sudan was operating under these old, very repressive laws.
Oh, incredibly so. The immediate problem these new bills were trying to fix was the existing national law, the Press and Publications Materials Act of 2009.
And the sources describe this law as just completely counter to any democratic values. It promoted censorship. It was a huge flashpoint between the ruling parties, the SPLM, and the NCP.
It was. So the new legislation, it wasn't just about making new rules. It was about suspending or fundamentally reforming those restrictive national laws.
Okay, so with that background, what was AMDISS trying to build? What was the foundation?
They laid down a very clear 4-pillar policy framework. And these pillars are foundational to understanding exactly what the executive branch was trying to undo.
So what were these sort of non-negotiables for them?
The first pillar was crucial. Absolutely, no hole. Licensing for people to practice journalism or to register print media like newspapers.
So the government shouldn't have the power to approve or disapprove who gets to publish words on paper.
Precisely. Registration should only be for, commercial or administrative reasons like registering any other business.
And that leads to the second pillar, I assume?
It does. Print media should be entirely self-regulating. It should be overseen by its own professional bodies, not statutorily controlled by the state.
Like a medical association or a bar association setting its own ethical standards.
Exactly that. The government shouldn't be dictating the ethical rules for every single journalist.
Okay, what was the third one?
The third was about restraint. The only media that should ever require a license were broadcast operators.
And only for a very specific reason.
For one single, narrow purpose: frequency allocation. This distinction is just vital because airwaves are a scarce, limited public resource. They're held in the public trust. Allocating them is really the only legitimate state function in media control.
So you're limiting state interference to the technical side of things, not the content. That is a huge distinction.
And finally, the fourth pillar. They pushed hard for the decriminalization of any media or journalistic offenses.
So moving things like libel out of criminal court.
Exactly. Shift it from the threat of jail time to civil litigation, where truth is an absolute defense.
This whole philosophy just completely reframes how media interacts with power.
It does. And nowhere is that clearer than in the idea of transforming the state radio and TV, which were, historically government mouthpieces,
right,
into independent, autonomous public service broadcasters. That was the entire point of the Southern Sudan Broadcasting Corporation Bill, the SSBC bill.
The ultimate power transfer.
That's what it was meant to be. Creating an SSBC that was accountable only to the Assembly, the legislature, representing the public, and not to the executive.
Okay, let's move into the fight itself, starting with transparency, the Right to Information Bill, the RTI Bill of 2009.
Right, so the ideal AMDISS bill, it sought maximum disclosure, transparency in public life. It was explicitly aimed at fighting corruption and upholding constitutional rights.
And the first major conflict was over the scope of that bill.
It was. The original liberal intent was that the RTI should cover information held by both public and private bodies. This was stipulated very clearly in the draft's guiding principles.
Wait, okay, if the main goal is government transparency, why did AMDISS insist on compelling private bodies to share information? What was the thinking there?
It was all about empowering the average citizen to protect their rights. The drafts wanted to compel private bodies, think massive infrastructure firms, land developers, major foreign corporations,
Sure.
to comply with information requests if that information was necessary for the exercise or protection of any right.
So, for example, getting an environmental impact report from a private mining company to protect your community's land.
That's a perfect example. And the moment they reached the executive, the GO-SS amendments targeted that exact provision.
Of course they did.
They tried to just remove the clauses compelling private bodies to comply. They argued it was an unnecessary bureaucratic burden.
But the implication is huge.
It's massive. Removing private bodies significantly limits the law's ability to expose corporate wrongdoing or enforce a citizen's constitutional rights against these powerful non-state entities. It just weakens the law's reach.
And we saw other sort of subtler attempts to water it down. Like AMDISS originally suggested the Information Commissioner should also be on the board of the Independent Media Authority, the IMA, just to avoid bureaucracy.
Which was a smart, efficient idea, but more problematically, GO-SS also introduced this vague language. It allowed information to be withheld if it merely prejudiced public security or privacy.
Without defining what that means.
Without narrowly defining those exceptions, which international law requires, that becomes a gaping loophole the government can drive any refusal through. It's the difference between protecting, say, a legitimate national security secret and creating a catch-all excuse for political concealment.
So we see a pattern in the RTI bill, weaken the scope, broaden the exceptions. But the fight over institutional control, the SSBC and the IMA, that's where the attempts at executive control became even more direct.
Oh, absolutely. Let's look at the SSBC first, the proposed public service broadcaster. To guarantee its integrity, its editorial integrity, the original bill made it accountable only to the Assembly.
To the elected representatives of the public, not to the ruling party in the executive.
That was the idea. But GO-SS wanted to maintain that executive oversight to make sure the broadcaster remained a tool of the administration.
And their interference was immediate.
Immediate and surgical.
Yeah.
They amended Section 6.1 to make the SSBC accountable directly to the president. And even worse, they completely removed the clause, Section 6.2, that guaranteed the SSBC's autonomy from the government in its day-to-day operations.
So you're turning a public service institution right back into a state propaganda machine.
That's the effect. And crucially, they tried to control the people running it. The sources show that GO-SS wanted to allow the president or a minister they appointed to remove board members just on their own initiative.
That's not just changing a rule, that's holding a loaded gun to the head of the SSBC board.
It is. The original draft required a 2/3 majority resolution passed by the Assembly for the president to remove a board member. That 2/3 requirement was like a legislative shield, a bulletproof vest.
To make sure the board couldn't be fired the minute they broadcast something critical of the government.
Exactly. Removing that instantly compromises the independence of the entire SSBC.
Okay, let's turn to the IMA, the Independent Media Authority, the regulator. The initial bill designed it to be a truly autonomous commission with all these specialized internal structures.
And those specialized structures were where GO-SS focused its deletion efforts.
They just started cutting things out.
They stripped out several vital internal bodies. This includes the Press and Broadcast Complaints Board, the Hearings Panel for Formal Complaints, and even the essential technical sections like broadcast frequency licensing.
Removing the Press and Broadcast Complaints Board, that seems especially damaging. Wasn't that the whole mechanism for self-regulation? Keep the state out of content decisions?
It was. It left a serious structural and frankly a philosophical gap. By removing those internal mechanisms, GOSS signaled this major lack of commitment to the principles of journalistic self-regulation and transparent oversight. The IMA was supposed to be robust, and now its internal organs were gone.
Okay, so we've seen control through accountability shifts, control through just stripping out structures. But the final, and maybe the most significant amendment, targeted that core AMDS principle against licensing all media.
This was the ultimate subversion tactic. It was designed to replicate the repressive licensing system that was used in the North before the CPA.
The very thing they were trying to escape.
The very thing. The entire policy was founded on the idea that only broadcast operators needed licensing because of frequency scarcity.
So how did they do it? How did they try to sneak in blanket government licensing for all media, including print, into this bill?
It was done through a very simple yet catastrophic definitional switch. It's buried deep in the text. The original draft mandated licensing only for a broadcasting service. GOSS replaced this term with the generic media service. Then they defined a licensee as someone licensed to provide a media service.
And media service, under this new definition, included newspapers, publications, the internet.
Exactly. By changing that one critical word from broadcasting to the vague media, they dramatically expanded mandatory licensing from scarce radio frequencies to all forms of media and journalism. Every newspaper, every local publication, every digital content provider.
That is a regulatory bait and switch masterclass. It's like arguing that because you need a specific permit to run a taxi service, the airwaves, you should therefore need a government license just to write a pamphlet and hand it out on a street corner.
It completely reverses the core liberal tenet of the entire bill. It violates the fundamental principle that was the entire foundation of the reform, that statutory licensing of print and internet was forbidden and self-regulation was the mandated path forward.
It just seems that no matter the bill, whether it was about accessing information, running a public broadcaster, or regulating the press, the executive branch found a way to reinsert centralized control.
That sustained effort reveals this deep reluctance to cede control over the narrative and, a fundamental skepticism toward truly independent journalism as a force for good governance. The sources just lay bare this divergence between a stated commitment to international democratic standards and an actual preference for maintaining an apparatus of state control.
So we've tracked a truly tense deep dive today into this crucial legislative battle. We've explored the dramatic tension between the ideal democratic media structure proposed by AMDISS and these determined attempts by the executive to insert mechanisms of centralized control across all three of these bills.
And the documents we reviewed, they make it absolutely clear what the recommendation was. Reinstate the original liberal drafts from March 2009 and suspend the pre-existing restrictive laws to meet the democratic objectives promised by the CPA.
And the key success indicators were pretty straightforward. Legal protection for freedom of expression, a fair broadcast licensing system,
and absolutely no undue licensing or restrictions on who can be a journalist, and of course the establishment of a robust self-regulatory system for print media.
The essential challenge laid bare here is whether these new institutions, even once they're enacted, can ever truly achieve operational autonomy.
Right. Can they escape the trap of executive interference, especially at these key control points like board member removal, budget determination, or through those, insidious, subtle changes to legal definitions we talked about?
It's a fascinating and I think necessary reminder of how small legal amendments can successfully derail these large democratic transitions. You can change the meaning of freedom with a single word.
Indeed. And it leaves us with a final provocative thought for you, the listener. The sources conclude that dialogue and vigilance are necessary even after these bills are enacted into law. Given how persistently the integrity and independence of these regulatory bodies were targeted by the GOSS amendments, from controlling appointments to removing key self-regulatory committees, what non-legislative civil society or journalistic mechanisms do you think are essential to continually guarantee the operational autonomy of institutions like the Independent Media Commission, regardless of who holds executive power?
Something to mull over until next time. We'll see you soon for the next deep dive.